intanto poi per il momento presento i colleghi e poi dopo, questa la mettiamo dopo magari. Possiamo partire da quella precedente con i nomi. Ok, sì, possiamo iniziare. So good morning everybody, and welcome to this first parallel session managed by EVERSHEDS Sutherland. We, of course, all of us with my colleague, we thank the LEAR organization for giving us the opportunity to sponsor the event and to contribute to the discussion. I have here an outstanding panel as well of my colleagues coming from different offices of our firm, which I'm going to introduce first of all. So we have Eline van Nimwegen from the Netherlands. We have Risto Rooster from Estonia, Charlie Marchilli from the UK, and Daniel von Böfen from Germany. And I'm Alessandro Greco. I'm a partner in the competition and trade team of the Italian office at EVERSHEDS Sutherland. In this session, basically, we wanted to cover the theme of joint venture between competitors in large energy infrastructure project, and cover all the possible issues and concern under a competition law perspective that this kind of cooperation may trigger. And we want to actually cover this topic starting from a case study, because our firm was involved in assisting two companies, major competitors, in a big project in the Netherlands. Starting from this case study, we want then to cover the different aspects of the joint venture and the different phase of the operation of the joint venture, with all the competition law implication and possible developments of the case law and legal analysis. So I would start giving the floor to Eline from the Netherlands, introducing a little bit the case study you were involved in about this project, and then we'll go through the other panelists. Eline, the floor is yours.
Thank you, Alessandro. So the case study, so we will go through the different topics in relation to collaborations between competitors, and we'll use this Dutch case study, which is based on an actual example of the Dutch Competition Authority, Project Aramis. It was published in June 2022. And so, as you may know, the Dutch Competition Authority is one of the front runners when it comes to sustainability, and they seek to give as much room as possible to ESG initiatives. So in this case, it was Shell and Total Energies, the two competitors who wanted to cooperate in a project realizing CO2 storage in the North Sea. Parties had planned to jointly market a volume of 5 million tons CO2 per year for carbon capture and storage services in depleted offshore gas fields off the shore in the Dutch parts of the North Sea. In the first phase, the cooperation would actually combine of joint production, so providing shared infrastructure in preparation to supply these CCS services, and joint marketing, so setting a joint offer for all CCS services based on a jointly established tariff. And all with the objective to allow emitters that could not immediately alter their processes to decrease CO2 emissions and contribute to the Netherlands actually achieving its sustainability goals. So actually, just to make the guidance that parties sought in this project was actually around the joint commercialization of the project and not about setting up the joint venture, mere to control, because that was done separately. But during our panel, we will go through the different aspects of such cooperations.
Thank you, Eline. So we will start with basically covering the phase of a joint bidding in a project among possible competitor or potential competitors. And I would ask Charlie Marchilli to guide us through this phase of a joint bidding, possibly among competitors.
Great. Thanks, Alessandro. So yes, joint bidding between competitors can raise competition issues right from the early stages of their collaboration. In this case, Company A and Company B, as described by Eileen, are both global energy companies who, in the normal course of their business operations, would be considered competitors to one another. So, of course, there are some very serious competition concerns that could arise in such an agreement. The first thing we have to do is draw a distinction between an open collaboration agreement such as this one, where the parties are intending to bid jointly and are looking to form a joint venture vehicle in order to do so, and the other kind of joint bidding agreement, which would be a hidden agreement between competitors to coordinate how they intend to bid in response to a tender, or whether or not they will in fact bid or not bid in response to a tender. If this kind of hidden agreement was to exist between competitors, then all major competition authorities around the world would consider this to be a bid rigging agreement, a hardcore restriction of competition, and if investigated by a competition authority, very likely to result in high fines and potential other enforcement action against the individuals involved. However, from the facts, as outlined by Eileen, it's clear that this is not a secret cartel bid rigging agreement, and in fact it is a legitimate joint bidding or bid consortium arrangement. Even in this scenario, however, competition authorities do consider that consortiums between competitors can have negative impacts on competition by affecting the price that they may bid in response to the tender, the quality of the services that they provide to the customer, and also innovation, because ultimately it reduces competition between two potential suppliers. So it is possible that even this legitimate joint bidding arrangement could still raise some competitional concerns.
Thanks, Charlie. But what are the key factors to establish whether there is a competition law risk in the joint bidding itself?
Okay. So really the key thing that we need to consider at this early stage is whether or not Company A and Company B are considered actual or potential competitors to take part in the initiative. If the parties can legitimately be considered not to be competitors, then Article 101(1) of the TFEU will not apply to the joint bidding arrangement, and we can see that there will not be any competition concerns. However, if the parties are considered actual or potential competitors, then this joint bidding may restrict Article 101(1). In order to determine whether or not the parties are competitors, the key question is to ask is, if this joint bidding arrangement did not exist between the two companies, would they have been able to bid for the project on their own, and would they have in fact bid for the project on their own? The mere theoretic possibility of the parties bidding is not enough. It's not enough to say that Company A and Company B are both energy companies, so of course they're competitors for this project. We need to look at the actual individual details of the project and take into account whether or not each party is capable of competing for that project in their own right. So this includes an assessment of the size of both businesses, the level of financial investment and risk that is involved from both competitors, and importantly, the individual expertise and capability that each competitor has to conduct this project on their own. It's also necessary to consider the tender rules for the particular project, such as whether or not individual bidders are required to submit a bid for the whole project on their own, or whether or not the tender rules allow them to submit bids for individual lots or individual aspects of the project. Because while Company A may not be able to bid for the entire carbon capture project, they may be able to bid for one particular phase or stage. And so if the rules allow for you to bid for a particular stage, then this may mean that you are still considered to be competitors for that stage. And this may be the case even if only one of the parties is able to bid. So this does require a real particular facts-based analysis of both of the competitors and the particular opportunity to understand whether or not they could be considered to be competitors.
Okay, Charlie. So let's assume that the parties can be considered potential competitor. What are actually the key elements to basically identify whether there is a risk that the joint bidding could restrict competition under Article 101?
Yes, thanks, Alessandro. So, on the basis that the parties are competitors, this agreement could restrict or distort competition under Article 101. And so in order to assess this, we need to take into account a number of considerations. First of all, we need to look at the market generally and the parties' position on the relevant market. So we would look at the product or services involved. So in this case, it would be the delivery and supply of carbon capture energy projects. We would look at the parties' market share and presence in this market. And then also the number of other potential suppliers of these type of products and their market shares as well. We'd also look at the content of the actual bidding agreement to understand what restrictions that agreement places on competition more generally outside of this project. Even if we get to a position where we think that this agreement is unlikely to have a restrictive effect on competition because the market shares of Company A and Company B are low, and there are plenty of other competitors who are available to bid, and so Company A and Company B joining together does not mean there is a lack of competition for this project. We still have to consider the usual rules on the exchange of commercially sensitive information between competitors, because at this stage there is no formal JV or formal arrangement between the parties. So it's important and, well, it's vital to remember that the parties can only exchange the information that is absolutely necessary for the joint bidding exercise, and then it's kept on a need-to-know basis only. So only shared with the individuals at the parties who are involved in the joint bidding tender exercise, and not shared more widely within the companies to allow them to coordinate their behavior on markets outside of this joint bidding exercise.
Thanks, Charlie. So if there is an impact on competition, there is still room for a possible individual exemption under Article 101(3).
Yes. If following our analysis, we found that actually we thought that because of the two parties coming together, there could be an impact on competition, because actually they were the two major players for these type of services, and there was a lack of other potential bidders, then we would conduct what's known as a Article 101(3) efficiencies exemption analysis. And basically, in order to satisfy the requirements of the EC on this, and Eileen will come and talk about this in more detail, we would need to show that the joint bid allows the parties to submit a more competitive offer than would have been the case, or that they could have submitted on their own, by virtue of entering into this joint bidding agreement. We'd also need to show that the joint bid results in benefits and efficiencies that will be shared with consumers, and ultimately the joint bid does not result in the restriction of competition. I'm sure as any lawyers in the room appreciate this is a very complex exercise, which involves a large amount of information and financial detail from both parties. And unfortunately, the regulators do not provide any legal sign-off. This is an assessment that is conducted by the parties and their own legal counsel. So the burden falls on the parties themselves to determine whether or not they satisfy the thresholds under Article 101(3). This can present some challenges, particularly in large energy projects, which require a huge amount of financial investment and burden on the parties, as shareholders and board members may want to have some certainty that any legal risk is managed. And in this situation, if we were presenting that there could be a restriction, then it may not be possible to present them with any certain sign-off from an authority that they won't be interested in this in the future. Eileen, you'll pick up on that, I believe. Thank you.
Eileen, you want basically to pick up on this and explain a little bit more also about the competition law analysis made by the ACM in actually assessing your case?
Yeah, so I will discuss the competition law analysis done by the Dutch Competition Authority. But maybe first, by way of background, the Dutch Competition Authority, they issued draft sustainability guidelines in 2021. So way before the adoption of the new horizontal guidelines. And the main difference with the position of the Commission when it comes to environmental damage agreements, which relate to decreasing negative external effects on the environment, is that the ACM suggests not to only look at the effects on the actual users, but the effects on society as a whole. So basically, if the competition law restraints may not sufficiently benefit the users, but do sufficiently benefit the environment, it takes a position that you can actually that the conditions of 101(3) can be met and to have the collaboration exempt. So the ACM actually lobbied with the Commission a lot in order to try to get this more generous position into the guidelines. It has not been followed by the Commission. The guidelines do state that collective benefits can be weighed, but only where two markets are related, and provided that a group of consumers affected and the group that has the benefits is substantially the same. And they also put a lot of emphasis on the substantiation and quantification of such benefits. And the ACM is is a bit more loose when it comes to such substantiation. The ACM has currently announced that they're looking at the gaps between the two, their own guidelines and the horizontal guidelines. They still need to come with an official statement, but they already said that they will probably deal with it by using their prioritization rules. So basically saying, well, if a project follows our own guidelines, then and maybe not the horizontal guidelines, we just may not come after. We just don't come after you. So. In this case, the ACM explored three routes. So no restriction of competition because parties entered into a new market, an exemption under the specialization block exemption regulation, or the exemption under 101(3). So the ACM considered that the project could potentially restrict competition because of the joint setting of prices, capacity and quality, and because the agreement would last for 15 years. And although it's a Dutch project relating to this infrastructure project in the Dutch parts of the North Sea, the ACM concluded that there could be an effect on the EU market, given the international ambitions of the project and because it covered the full territory of the Netherlands. So that also shows you the split that you may get into, because the ACM may want to provide more room, but under the EU guidelines they cannot completely deviate, and it may take some guts as a party to rely on such room that the ACM provides, where there may be other authorities around the corner who may have a different opinion. ACM also ruled out the application of the block exemption regulation because of parties' market shares. And so it did an assessment under 101(3). The outcome was that the ACM thought that the project was likely exempted. First of all, because of the improvement or progress, so the first condition, and it was an environmental. Because it qualified as an environmental damage agreement, giving more options to emitters for a solution to decrease their CO2 emissions, without affecting actually the options already available to them. Then the second condition is then the fair share for consumers, which then is the actual, the crucial one. They concluded that the emitters would actually be better off because of this increase of possibilities, and because there would be less CO2 pollution for society, which would benefit consumers and society as a whole, and would lead to cleaner air. And so in this case, there was actually no quantitative assessment done, because the fair share criterion does not lend itself for such projects. That's what the ACM finds, that the sustainability benefits would clearly outweigh the costs based on a rough estimate only, and that the market shares of the joint initiative would potentially be below 30%. They also looked at indispensability and that there would be no elimination of competition, because it was about marketing only, jointly marketing only 5 MTPA, and there would be 17 MTPA still available to third parties. So maybe to wrap up with a few takeaways, is that potential restriction of competition is easily established in case of a joint setting of competition parameters, even if if parties are creating a new market, which takes parties to the 1013 assessment, which Charlie already mentioned, is a bit more uncertain and more burdensome. Being able to rely on a block exemption regulation may make your life a lot easier. So when you're designing a cooperation, it's good to have a look at that, looking at joint venture, picking your joint venture partner, the scope of the cooperation. Thirdly, you must have a clear view at the outset of the scope and the geographical reach of the cooperation, especially if you want to rely on any potentially more favorable regimes, such as the Dutch competition law regime. Seek guidance from the authorities. That's what the ACM actively invites parties to do, and also the Commission in its new guidelines. So that may actually give you some comfort. And finally, perhaps most importantly, don't let competition law scare you in this sense.
But Eileen, now that we also have the horizontal guideline from the European Commission published with a specific section covering sustainability agreement, the interesting question would be, would the outcome of the ACM analysis in your case have been different, applying the horizontal guidelines of the European Commission rather than the Dutch authority guidelines?
Yeah, well, I don't know for sure, but the lawyerly answer would be possibly, and that's mainly because it probably would have required the ACM to have a closer look at these positive effects of the collaboration, because of that divergence when it comes to the consumer benefit. So I do not rule out that the project would still have been exempt, but it would have been a more bumpy road because of this increased analysis that it would probably needed to be done.
Okay. Thank you. Now I would ask Daniel to step in to guide us through the creation of the joint venture, so setting up the joint venture and all the different legal considerations to be made in that respect.
Thank you, Alessandro. I'm not sure I'm covering all the considerations, but at least the major ones. Yeah, sure. If we have a cooperation or project like the one Eileen described, obviously merger control is the question. You have to ask whether merger control is applicable, whether notifications are required, or clearances, merger control clearances. Now, generally, if you approach as a transaction party merger control, it's not always seen with pleasure. Yeah? I mean, it's costly, it costs time, it costs efforts, and so on. So you may generally be happy if you don't have to undergo a merger control procedure. That may be different in this kind of scenarios, because obviously merger control clearances provide some form of legal certainty, which can help you to maybe avoid some of the discussions and the uncertainties which are related to what both Charlie and Eileen described. So merger control may actually be beneficial even for the transaction parties. Here, in these cases, obviously assuming that at the end of the day there's a clearance. So what are the key aspect, or looking at the European Union and the most member states? The lawyers among you will know that for a joint venture to be subject to merger control rules, the joint venture needs to be a full function joint venture. Now, looking at greenfield investments like this one, like in our case study, that's not obvious, at least, that this is always full function. There may be various issues. For example, the Commission says in the consolidated jurisdictional notice, its internal guidance on this, that if there are still approvals, outstanding regulatory approvals or something, the joint venture may not be on a lasting basis. So one of the criteria would not be satisfied, or the parties may decide to sell the products produced by the joint venture only to the parent companies, which then means that the joint venture will not have access to a market. So at the end of the day, it would not be considered as full function. As I said, that's a case-by-case analysis, but the result may well be that you end up with a joint venture which is not full function, which then would mean, okay, it's not notifiable to the European Commission, or most member states do have that criterion, that full function criterion. Now, sitting here as a German, obviously, I can tell you not all member states have it. There are some member states who don't have the full function criterion as a condition for merger control notification. So Germany, for example, Austria does not have it, Poland does not have it, and looking outside the EU, we can look at China, South Korea, and Brazil. And that has, that's a free choice. Why not? Let them have other conditions. The problem in this context is, and that's what we have been experiencing in this project and similar projects, is that there's often in these jurisdictions no proper local nexus criterion relating to the joint venture. What I mean by that is that if you have two large globally operating companies coming together forming a joint venture, they will most likely exceed the merger control thresholds in Germany, in Austria, in Poland, in China, in South Korea, and in Brazil. And they will end up with finding that their lawyers telling them, okay, you have to notify this joint venture, which is really limited in its impact to, well, maybe to the whole of Netherlands, but it takes place in the North Sea off the Dutch coast. It has a very fairly local impact, and clearly has no impact in Brazil or South Korea. But you nevertheless have to notify it in Brazil and South Korea, because the parent companies are meeting the applicable thresholds. That's a nuisance, and that's something you have to deal with. And at least if you are a very compliant company, which I'm sure you are all advising, at the end of the day, you may not be able to avoid having to file this in these jurisdictions. So that's merger control. If we look at the maybe new kids on the block of merger control, like FDI, foreign direct investment control, and also the very recently adopted foreign subsidies regulation, you could wonder whether greenfield investments also need to be notified under these regimes. And we just heard in the plenary sessions, there are lots of complaint about too much regulation and too much state intervention, and obviously that might be another example for this if there are further notifications required. Foreign subsidies regulation. Unlikely to apply to greenfield investments because there is there's a merger control regime under this regulation, but it essentially only applies if the parent companies contribute revenues worth of 500 million into the joint venture, which we can assume will not happen in greenfield joint ventures. So normally I would take as an assumption the foreign subsidies regulation will not apply in this kind of scenarios. There might be others where it becomes relevant. FDI, foreign direct investment, is certainly a different story. As you may know, it and as we just heard earlier in the session, whether FDI regimes apply mostly depends on where the parties and the target company or the joint venture in which sectors they are active. Now we are speaking of energy infrastructure projects. Energy infrastructures are considered in most, notably EU jurisdictions, as critical infrastructures, so that might be FDI relevant. Then again, we have, in many jurisdictions, we have certain quantitative criteria, meaning that critical infrastructures are only FDI relevant if certain thresholds are met. For example, a solar power plant is only considered a critical infrastructure if it generates so much power per year. And with a greenfield investment, which only will produce something in 7, 5, or 9 years, that may not be triggered. So Probably my rough estimation would be that in most FDI jurisdictions in the European Union, this would not be notifiable, but it's certainly different. In the US and Canada, for example, greenfield investments can be covered fairly quickly or can be within the scope. And at least in Germany, we have the discussion, the policy discussion right now, whether the FDI regime should be broadened and specifically to cover this kind of investments also to become subject of FDI.
Thank you, Daniel. So basically, we want also to discuss a little bit about the operational phase of a JV and all the different considerations to be made in terms of an antitrust risk exposure under the standard Article 101 analysis. So I leave you, Risto.
Yeah, thank you very much, Alessandro. Now we have entered maybe the most interesting phase of a joint venture, because before that everything was on the paper. We have a company now, we have a joint venture, we have managed all the different regulatory hurdles, and now we have to start working with it. Maybe we have made some promises to the competition authorities as well on the way to that. And we need to live up to the promises we have made. We're basically talking about two sides of a coin. There's the commercial side, and this is most important, I guess, for the parents and the joint venture. And then there's the legal side, which interests me as a lawyer, but probably client is not so happy about knowing about those, but it has to. So it's unavoidable. And well, basically the rules relating to the creation, we talked about Article 101. It's the same rules are also relevant in the operational phase. But there is one aspect which maybe needs a little bit more attention, or creates extra problems, and this is the role of the parents and what they are doing there. Because if we think about the joint venture, what joint venture, first of all, it needs resources, assets, tangible, intangible, know-how, IP. It needs some input, raw materials, maybe some support functions, IT systems, and so on. Of course, employees, key employees, C-level employees, management, guidance, organizational and financial structure. This is what it needs. What it does is, well, it constructs something, it produces something, sources something, then it distributes it. It has several models it can use for distribution. It can distribute itself, it can use sub-distributors, it can use the parents as distributors. And there is where the parents come in, all of this, because the parents are those who provide to a joint venture. They provide the necessary means for the venture to function. They basically manage it, they direct it, they give it purpose or define its purpose. They have a business plan, they have a budget. They provide all those assets which I mentioned. Sometimes they supply raw materials, and sometimes they distribute the output for a commission. They also, when they give some raw materials to a joint venture, again, they do it for a fee. They don't do it free of charge, usually at least. So the parents have a dual role here, and they have dual interests. They are shareholders, and of course they want to profit from there, maybe get dividends, maybe receive the increase of value of a joint venture, but they also might be commercially interested in the everyday activities of a joint venture, so they gain from there as well. They sell something to a joint venture or buy something, maybe cheaply, to resell it. And what are the root of antitrust concerns, or the main antitrust concerns, which I can highlight, are relating to, first of all, research and development and IP, because in many circumstances or in many situations, a joint venture would need IP from somewhere, outside its own organization. Mostly maybe from the parents, but not always. It could also come from third parties, when someone has to negotiate with them, agree about the terms and conditions of the IP, maybe agree on exclusivities, so the non-competes, or how the products or goods which have been produced using that IP, how this product or goods group can be disposed of. And it's important to keep in mind that whatever arrangement there is between the parents and between the parent and the joint venture, it cannot suffocate normal competition and innovation. So there has to be some room for innovation, and also the foreclosure of the markets is, I guess, a problem area here. Secondly, exchange of information, and it's very crucial for any joint venture to operate, is the information flow, because it cannot do it if information does not flow from parents to the joint venture, or joint venture to the parents, sometimes between the parents, and those have to be properly managed. First of all, parent to parent, as long as this relates to the activities of the joint venture, when it's, as far as antitrust rules are concerned, it's probably okay, whatever they do, because this is their business. That's why the joint venture was set up, and of course the parents can manage it. Anything which is outside the everyday or normal activities of a joint venture is in the, so to speak, problem zone, because it's really, if it's outside the geographic scope or the product scope of a joint venture, then it's information which joint venture actually wouldn't. Well, the information exchange doesn't really benefit the joint venture, and there's a problem there. And definitely wouldn't be okay any information exchange between the parents on sensitive issues of the activities of the parents themselves. Because we are talking today about the joint ventures between competitors, so horizontal joint ventures, so to speak, and there has to be competition outside joint venture. So that's what the parents, they cannot use this joint venture as a platform for facilitation of some anti-competitive aim. So, and we as lawyers have to warn them and address that risk. Then information from parent to joint venture. Whereas the rule of thumb here is whether the joint venture actually needs this information to function or doesn't. If it doesn't, then probably it shouldn't be given to the joint venture, but even if it is given, at least some proper safeguards should be put in place which ensure that this information does not go further somewhere, down the distribution line to where it shouldn't be, or to the other parent perhaps. It shouldn't maybe reach there as well. It's really a case-by-case analysis. Information between joint venture and parent, or the direction is from joint venture towards the parent. Again, it's important for the joint venture to be able to transmit such information, also for the parents to receive it, because, as said, parents are those who are making decisions. They manage it. It's their business. They have created it and want to implement it, so they need information about profit, about revenues, about the costs. So this enables them to make management decisions. What is a problem area is probably information, or specific information about customers and prices which are charged from the customers, especially if the parents are also, outside the joint venture, also dealing with the same customers. Joint production, if a joint venture is about jointly producing something, of course, consolidating resources is a good thing. There could be cost savings there, could be streamlining of operations, optimization of resources, it's all good. However, if market power is created due to a joint venture, then consumer might actually be worse off because of a joint venture and not better off. So this is something which needs to be looked into. Also, discriminatory practices could be concerned here, especially when parents face competition outside joint venture, so they naturally, for them, in a commercial point of view, it would make sense to try to fight that outside competition. So also price control, output limitations, those are all possible risks which need to be addressed. Joint distribution is basically the other side of production. Joint distribution, joint venture. Again, the main concern is market power. Also, non-discriminatory access is necessary. Concerns are relating to price alignment between parents, so that should be addressed. So the key takeaways on the trading dynamics, in my view, are that parents are both shareholders and they are in many ways, business partners of a joint venture, so they should remain at least competitors outside the joint venture. They should remain competing with each other outside the joint venture. And if there is market power involved, then non-discriminatory conduct would probably be necessary.
Having touched upon the different aspects of the analysis on the joint venture and this form of cooperation among competitors, I think it's also interesting to mention another approach to the sustainability assessment taken by a different competition authority, and this is again a case that, Eileen, you have come across.
Yeah, thank you. Just as a practical example, so what we see in practice is that not all competition authorities are per se very comfortable yet with how to assess sustainability in their competition law assessment. So there's one case that we've been involved in Brazil with CADE, and there was also a sustainability project. Has been a lot debated by scholars, and because of the position that CADE takes, they were very much on top of this project. First cleared, and then it got back to another commission within CADE because they wanted to have another view. And what we saw there is that actually, in order to avoid having to deep dive into sustainability competition law assessment because they're not really sure how to do it, or maybe for some other reasons, or for practical reasons, what they look in is they try to find practical safeguards. So they ask for a lot of commitments from parties in respect of their competition law compliance. So they focused on competition law policies that they needed to officially adopt and abide by, appointing chief compliance officers and all these kinds of safeguards. So a takeaway here is that also, outside the competition law assessment and having to do this analysis, and also these practical safeguards that may help you in the preparation phase, but also in the creation phase, but also in the operational phase, and that may actually help to bring your project off the ground.
Eileen, so starting from the case study in the Netherlands, we have tried to basically explain the different possible aspects of concern and the legal analysis required in any form of joint venture, especially in relation to energy infrastructure project, but not only. Of course, the Dutch case is a very important one because it shows an application of the sustainability principle to a form of cooperation in a big infrastructure project. Probably we have not other examples of similar assessment made by other competition authorities throughout Europe so far, unless you tell me otherwise. So I would ask you if you have any comments or observation, something that you want to ask, maybe.
Hi, good morning. Ciao Alessandro. My name is Alessandro Noce and I work from the Italian Competition Authority. I'd just like to know your point of view as a lawyer, because we have been talking about sustainability agreements since the last 3 or 4 years, but as we realize there aren't a lot around. I mean, at the end of the day, we see a very few cases around. So we have talked more than, as an enforcer, I haven't seen any. So it's something, Now, my question is, do you think that this is due to maybe what Charles was saying about the uncertainty which is still going on even after the coming out of the horizontal guidelines, and so you maybe suggest your clients not to do it? Or maybe there is another reason, which is that firms are not so interested in collaboration in these fields, because we are all doing this kind of talks, but we must start from a decision, a business decision to collaborate in many fields, circular economy, energy, waste disposal, animal breeding, anything. But why we don't see a lot of this? Did you ask yourself? You have an answer to this question?
I can offer a thought. Maybe it's a good thought, maybe it is not. But if we think about, traditionally 101, Section 3, what the Commission and I guess national competition authorities are looking for, they're looking for clear benefits which are passed on to the consumers. So traditionally, everyone has been thinking about, price reductions. The prices have to go down. Now, when we are looking at the quality, then we are already stepping kind of further from that thought, because quality probably increases costs. And now if we go to sustainability, then my statement would be, maybe prove me wrong, I think this increases costs even more, which means the prices actually go up. And I think that you mentioned that maybe the companies are afraid to rely on the sustainability defense. I think they are afraid because they don't know how the authorities are actually going to react to it, because the prices will go up. It's difficult to argue the benefit to the consumer, and I know, of course, the society on the whole will benefit, but it's difficult to argue how it benefits the consumer still. If we let's say if we improve the living conditions of animals, what would actually the society get from it, or for the final consumer get from it? Good feeling that the animals are doing well. Just a thought. Okay.
Yeah, maybe one observation from my side is actually from a Dutch perspective. Since the Dutch Competition Authority issued their draft sustainability guidelines, there have been published already 5 or 6 opinions in respect of corporations. Not always it was as complex as this energy infrastructure project, but there have been multiple cases where parties actually sought guidance. So I think that's it does show that some parties are willing to cooperate, and we've actually also in other energy projects we've actually assisted large energy companies who did projects together. So just from my side, it does seem to happen.
Just very briefly, I thought it was interesting, your comment from the Italian Competition Authority. Andreas Mund, the president from the German Bundeskartellamt, famously said that there are much more conferences about sustainability than cases. Obviously, next question you could ask is whether you are conveying some form of skepticism, if I may be very cautiously saying that, and maybe the Dutch authority, which is much more open to this kind of agreements and assessments, maybe then they attract more cases. I don't know, and I can't prove it, but that obviously might also play a role.
Are there any additional questions, maybe, or comments? Something you want to share, experiences? No. I think otherwise our session is over, so thank you very much again to everybody, and we'll talk later.